alternative dispute resolution methods. Knowledge of methods such as mediation and arbitration for resolving contract disputes. Avoid disputes and resolve contract issues quickly and cost-effectively with ADR methods. What are the key issues related to dispute resolution and dispute avoidance using ADR methods? Hello and welcome to our video on efficiently resolving contract disputes with alternative dispute resolution methods, or ADR for short. Dispute avoidance is a proactive approach to managing disputes that involves identifying potential conflicts and taking steps to prevent them from escalating into formal disputes. ADR methods, such as mediation and arbitration, can effectively resolve contract disputes and avoid costly and time-consuming litigation. To effectively use ADR methods, parties should consider some of the most important issues related to dispute resolution and dispute avoidance. The first issue is knowledge of ADR methods. Parties to a contract should have a basic understanding of the various ADR methods available, including mediation and arbitration, as well as their benefits and limitations. This can help them decide on which method to use in a particular dispute. The second issue is contractual provisions for ADR. Parties can include clauses in their contracts that require them to use ADR methods, such as mediation or arbitration, to resolve any disputes that may arise. These clauses can help to streamline the dispute resolution process and reduce the risk of protracted litigation. The third issue is the selection of the right ADR method. Parties should carefully consider which ADR method is most appropriate for the type of dispute they are facing. For example, mediation may be more suitable for disputes where preserving the relationship between the parties is important, while arbitration may be more appropriate for disputes where a binding decision is needed. The fourth issue is the selection of the right mediator or arbitrator. The selection of the mediator or arbitrator is critical to the success of the ADR process. Parties should look for a mediator or arbitrator who has experience and expertise in the relevant area of law or industry and is impartial and unbiased. The fifth issue is confidentiality. One of the advantages of using ADR methods is that they can be confidential, which can help to preserve the privacy and reputation of the parties involved. Parties should ensure that any agreements reached during the ADR process are kept confidential. The sixth and final issue is the enforceability of ADR outcomes. The enforceability of ADR outcomes can vary depending on the jurisdiction and the type of ADR method used. Parties should ensure that any agreements reached through ADR are legally binding and enforceable in the relevant jurisdiction. By addressing these key issues, parties can effectively use ADR methods to resolve contract disputes and avoid the costs and delays associated with formal litigation. So, if you want to avoid disputes and resolve contract issues quickly and cost-effectively, ADR methods may be the right choice for you. Thank you for watching our video, and we hope that you found this information helpful. If you have any questions or would like to learn more about ADR methods, please don't hesitate to contact us.